When we meet with you in an initial consultation, we'll explain the law to you to make sure that you understand it. And generally there are three areas that we have to prove in your case. The first of those involves liability. That means who's at fault for the accident. We will analyze that issue and, if need be, bring in experts to prove our case, to secure the evidence and prove our case. In addition to liability, the next important aspect of the case is damages. The legal term damages really talks about the harms and losses that you have suffered. Now, those could be the medical expenses that you have, the lost wages that you've had or that you may have into the future, and other out-of-pocket expenses that may exist in your case. Other harms and losses involved what we think of as pain and suffering, inconvenience, the loss of enjoyment of life that you've suffered up to this point in time and that may continue into the future. These are the areas, both economic and non-economic, that make up the damages in your case. So we have liability, meaning who's at fault, and then we have damages. And then we have the all-important injury causation element. And what that means is you may have some damages, but we have to be able to prove in your case that those damages are related to the careless actions of the defendant. That they're not damages, they're not some pre-existing condition that you may have had, or that it's not some subsequent event that you were involved in that caused you harm.